representing our church as on a social action. I just want to give you some basics on the place there. If anybody needs a bathroom, we've got a unisex one in the back corner of the room. If you go straight through the double doors in the back and down about 15 feet on the left-hand side, there's a ladies' room. And if you continue to the front of the building and go left, there's a men's room out there. So plenty of bathrooms, and you're all completely welcome here. And the Social Action Committee is really happy to be sponsoring CELDF for this. So at this point, I'm going to turn it over to the first person who's going to be speaking for CELDF.
Introduce her. Come on.
I understand. Good evening and welcome everyone. Thank you for coming out to this very important event. My name is Kathy Miorelli, and I am so excited to have all of you here tonight. I am with the Pennsylvania Community Rights Network. At this time, I'd like to thank our co-sponsors for this evening's event. Community Environmental Legal Defense Fund, Alliance for Sustainable Communities Lehigh Valley, Birch, Hawkendawqua, Catasauqua Watershed Association, Beyond Capitalism Working Group, Lehigh Valley Gas Truth, Lehigh Valley Vanguard, Lapoco Peace Center, Sludge-Free Upper Mount Bethel Township, Social Action Committee of the Unitarian Universalist Church of the Lehigh Valley, and Transitions Lehigh Valley. This is a very special moment for all of us, not only to have you here, but to have Thomas Linzey in the Lehigh Valley. I want to give you a quick history of how I came to be introducing this very important event. My community was getting dumped on, and at about the same time we realized that we had an increase in cancer rates. An increase in cancer rates from years of corporations dumping harmful substances. And I'm from the Tamaqua, the borough of Tamaqua. I thought that if we could convince the state agencies that we had a cancer problem, that the dumping would stop. Boy, was I wrong. Within a few years, I was elected to Borough Council. As a council member, I attended a sludge meeting in a neighboring township where I first met Ben Price and Thomas Linzey. Within a few weeks, I attended a CELDF democracy school, and at the end of the school, I engaged Ben and Thomas to help draft rights-based ordinances that would protect my community's rights. In doing so, we became the first community in the world to grant rights to nature. Now I sit on the board of the statewide Pennsylvania Community Rights Network. We work to support other communities that are protecting their rights by saying no to harmful corporate activities. This work is not easy. We have been challenged by corporations and our own elected officials. We've had lawsuits filed against communities we work with. But we continue onward, as these are the first steps in a long process to protect our rights and take back control over the future of our communities. We do need support, both financial and physical, from donors and volunteers. If you care about something in your community, talk with us about starting a campaign to protect your rights. The Pennsylvania Community Rights Network is offering a pamphlet written by Thomas Linzey for a donation of $10 or more. Please donate. We have a volunteer sign-up sheet over there and donation envelopes set up. At this time, I would like to introduce Chad Nicholson. He is the Pennsylvania organizer for CELDF, the national organization that Mr. Linzey will be talking about, that is encouraging and supporting the network of local community rights groups across the country today. Chad.
Can folks hear me okay? Yeah. Okay. And a big round of applause for Kathy Miorelli leading the charge in Tamaqua Borough. The first community in the world to grant rights to ecosystems in the world. And her work and the work of the people of Tamaqua eventually ended up influencing the national constitution in the country of Ecuador. Just 2 years later, in 2008, people in Ecuador heard about what happened in Tamaqua Borough. invited the Legal Defense Fund down there to work with their constitutional assembly, and then became the first nation in the world to actually grant rights for nature into the country's national constitution. So when folks say that what happens in your community doesn't have an effect on what happens globally, they are wrong, and Kathy's example is a perfect illustration of this. So Kathy's been an inspiration to all of us. A couple of quick words from me. Community environmental... Legal Defense Fund opened in 1995. We are a 501c3 nonprofit public interest law firm. We opened to protect communities, mostly rural communities in Pennsylvania, who are facing industrial threats to their health and safety. So things like the spreading of municipal sewage sludge on farmland, factory farms, toxic waste incinerators, long-wall coal mining. These days, a lot to do with gas extraction, so fracking, pipelines, injection of toxic frack waste into the ground, corporate water withdrawals, you name it, the calls come in. Back then, we were a more traditional environmental law firm, which meant that we worked with communities to try to appeal permits that had been issued to corporations to engage in these projects. We basically found that the permitting process and the regulatory agencies themselves, such as the DEP, the Department of Environmental Protection, or as our communities call it, the Department of Everything Permitted. Most of these agencies are not there to actually do what their name says. They're there to actually legalize harms through the issuance of permits, and those permits then permit that activity to happen, and they legalize a certain amount of harm that goes along with that activity. They're called regulatory agencies for a reason, which is that they regulate the amount of harm. They don't stop it, they don't protect the environment, they protect corporations by legalizing a certain amount of harm, and they then regulate that harm. We found that system to be a sham, and that it didn't work to further the mission of our organization, and that it didn't actually work to protect the communities that we were trying to help, so we don't do that work anymore. Thomas is going to talk about the work that we do in depth, but I'll just say that the work that we do these days is not necessarily environmental in nature. It's not about regulating the harm. It's actually about working with communities to assert their civil and political rights to determine the future of their communities and to ban harmful corporate projects that would infringe on those rights and that would harm the community. That's what we do. To date, we've worked with over 400 communities in Pennsylvania at this point. Over 100 of those communities have passed local rights-based laws that ban harmful activities like sewage sludge and fracking as a violation of the community's rights. They don't regulate it, they don't zone it, they don't try to sugarcoat it. They say we're actually going to ban these activities because they would violate the rights of our community to health and safety. So, that work began in Pennsylvania. It's now expanded to over 12 states across the country. Nearly 200 communities at this point across the country have passed some version of these local laws banning harmful activities within their communities. It's also expanding internationally now. I mentioned the Ecuador example, which had influence from Kathy's work in Tamaqua Borough. We're also currently working with governments in Nepal, India, Cameroon, the Maldives, Wales, England, and a number of other places as well. So the work that has grown out of rural Pennsylvania communities is actually now beginning to influence conversations on health and safety and even climate change worldwide. In addition, even though the title of our organization has environmental in the word, our work is also expanding into other avenues as well. These days we're getting calls from communities concerned about police accountability, campaign finance, worker rights, labor things, all kinds of stuff like that. What ties all of this stuff together are not the issues themselves. We don't have a fracking problem, we don't have a sewage sludge problem, we don't have a campaign finance problem, we don't have a police problem. From our perspective, we have a democracy problem, which is that the communities and the people who are most affected by these decisions don't actually have the legal tools and authority that they need to make decisions that are in their best interest and to actually govern the future of their communities. We have a democracy problem, and that's what our work is about remedying. In addition, out of this local work have now formed what are called state and community rights networks. So in Pennsylvania, we have the Pennsylvania Community Rights Network, which Kathy mentioned. We have similar organizations in Ohio, Colorado, Oregon, Washington, and New Hampshire. The role of those organizations is to actually continue to support the local work, as well as give that local work a platform at the state level to begin talking about and eventually force constitutional change. Because at some point we have to change our fundamental governing documents to not be used by corporations as weapons against our communities, but actually be reclaimed so that our constitutions protect the rights of our communities and people again. That's where we're moving. Constitutional amendments have now been introduced in Oregon, Colorado, and New Hampshire. Within the next month, we'll be rolling out a similar campaign in Pennsylvania to deal with constitutional change as well. Who in here knows the current process for amending the Pennsylvania Constitution? 1, 2, 3. More than usual, all right? Usually there's 0 hands that go up in a room like this. It's a nasty process. We have to ask our elected rulers in Harrisburg for permission to actually change our own constitution in Pennsylvania. We as residents, as citizens of the state of Pennsylvania, don't even have access to propose amendments to our fundamental governing document right now. That's off limits to us. It's outside of our pay grade. Only the smart people in Harrisburg can propose amendments to the Constitution. From our perspective, that's about as undemocratic as it gets, and that's going to be part of the campaign that we roll out within the next couple of months. Usually at this point, I'm seeing some long faces, especially in newer communities, because folks say, well, I just wanted to fight sewage sludge, or I just thought we had this small problem facing our community, and now you're talking about constitutional change. You know, holy crap, I didn't want to take on the entire state and, federal governments at this point. And so why? Why is it? Thomas is going to be talking about that in depth tonight, about how deep the structural issues go, how deep the lack of democracy actually goes. Because from our perspective, if we don't understand how deep these issues go, the proposed remedies and solutions that we end up chasing are woefully inadequate to deal with the size of the problem. We have to understand how deep this goes if we're actually going to have a shot at getting out of the massive mess that we are in. On that happy note, welcome. I will give a bit more background on Thomas and then turn it over to him. Thomas is a lawyer, obviously, with the Community Environmental Legal Defense Fund. He is admitted to practice in the United States Supreme Court, the 3rd, 4th, 8th, and 10th Circuit Courts of Appeals, the U.S. District Court for the Western and Middle Districts of Pennsylvania, and the Commonwealth of Pennsylvania. He's a co-founder of the Daniel Pennock Democracy School. It's a training program that we now run in 24 states. Has graduated over 5,000 lawyers and activists and community members. He's the author of a 2009 book called Be the Change, How to Get What You Want in Your Community. There will be another edition of that book being released later this year. In 2008, Thomas and other members of Legal Defense Fund assisted the Ecuadorian Constitutional Assembly to grant rights for nature for the first time at the national level in Ecuador's constitution. His work has been featured in the New York Times, the LA Times, Mother Jones, The Nation magazine, and he was named in 2007 as one of Forbes magazine's top 10 revolutionaries. He currently resides in Spokane, Washington. You're welcome for Thomas Linzey.
So I still can't figure out whether the Forbes magazine thing is a compliment or an insult. Figured that out when it came out. So I grew up in Pennsylvania, grew up in Indiana, went to IUP, graduated of IUP, graduated of Widener Law School. So this trip has been like a homecoming to me, seeing a bunch of familiar faces in a bunch of familiar places. And as Chad mentioned, the first 15 years of the work, first 12 of those 15 years of the work was almost exclusively Pennsylvania. This is where what some folks are calling a community rights movement in the United States got started. Was in very rural places in Pennsylvania. Actually, first municipality ever to pass a rights-based ordinance was in Fulton County, Pennsylvania, down in the south central part of the state. So what I wanted to do tonight was give you a little bit of an idea of how this work started. We didn't drop from Mars and start taking on the largest agribusiness and waste management corporations in the world. We didn't start here with thinking about revolts and revolutions and changing structures of law. We actually set out to do something quite simple with the formation of the Community Environmental Legal Defense Fund. And that was to provide free legal services to conservation-based community organizations. So these community organizations, neighborhoods, people coming together around kitchen tables to take on a project that was affecting their community. Those folks in the United States and in Pennsylvania as well have not had access to legal services over the past 40 years. Today, if you want an environmental lawyer to look over an ordinance or to do a land use appeal or to have a conversation with you, it can cost upwards of $1,200 an hour. just to have a lawyer talk to you about an environmental issue that's happening in your community, which is way beyond the reach of most communities who are trying to raise gas money and photocopies, to pay for photocopies and rub two dimes together. And so during that period of time, which was 1995, when the Legal Defense Fund was formed, for the next 7 or 8 years, we hung out our shingle, which for free legal services to represent those community organizations. So coming out of law school, we framed the problem as not enough lawyers in Pennsylvania doing this kind of work. Today we frame it quite differently, but back then we talked about not enough lawyers being available for these community organizations to do these types of permit appeals and that type of work. Unfortunately, also in the United States, the numbers are the same today as they were back in 1995. There are only 200 full-time public interest environmental lawyers in the United States today. 200 full-time public interest environmental lawyers in the United States today. So those folks that couldn't obtain legal services for pay are thrown back into that pot of trying to compete with each other to find a lawyer to represent them in these various projects. As you can imagine, when you hang out your shingle and it says free legal services to a community that hasn't had access to them for a long, long time, or ever, you can imagine the phone rang off the hook and people lined up around the block to actually obtain legal help. And the calls coming to our office during those early days were always the same, which was a community would call us on the phone and they would say, Mr. Linzey, we have a 15,000 head hog factory farm that's been proposed for our community by Hatfield Foods or Smithfield Foods Corporation. And we don't want it here. We want to be able to say, we want to say no to it because our vision of a sustainable community doesn't include a 15,000 head hog factory farm in the middle of our community, our municipality. And we would very proudly at that point put on our lawyer hat and we would say to them, well, whereas philosophically we're with you, if it was my community, I wouldn't want a 15,000 head hog factory farm in my municipality either. That unfortunately the structure of law in this country, the system of law in this country, dealing with municipal control over certain corporate projects at the local level, is this. And you can ask the corporate lawyers, you can ask the environmental lawyers, they'll give you the same answer. It's been well-settled law for the past 150 years in the United States. But when a corporation obtains a permit for a specific use within your municipality, could be a factory farm, could be a frack well, could be a frack injection waste well, could be planting genetically modified seeds, could be pesticide spraying from helicopters, could be any of these thousands of different projects that corporations propose in communities every day, which they obtain permits for from either the state or federal government, that your community is prohibited from banning that use. Okay? So again, communities calling us, and most people I've found in the United States don't understand even how that piece of the system of law works. But your municipality, your municipal community is prohibited from banning a legal use. So L-E-G-A-L, a legal use. And that's the status of the law today in the United States. Now sometimes folks say to themselves, well, wait a minute, that's not true. Our municipality can ban a legal use. We can do it through zoning ordinances. We have zoning and land use ordinances in our municipality. Well, not quite. Zoning ordinances in your municipality are about separating out incompatible land uses from each other, residential from commercial, commercial from industrial. But if you attempt to use your zoning ordinance to actually ban a legal use within your community, the first thing that's going to happen is the corporation affected by that ban is going to sue your municipality. And among other things, they're going to sue your municipality for violating their corporate constitutional rights. Okay? Always sounds funny to say, perhaps, or bend our brains around, but corporations today have constitutionally protected rights against actions of your municipality if you attempt to ban or prohibit a legal use within your community. So again, wearing our lawyer hat, when the community would call us and they would say, we want to say no to this particular use, this particular project coming in, and we would answer them back by saying, we agree with you, but unfortunately the structure of law does not allow you to say no to this legal use coming in. But however, we would say to them, we're happy you called, because the type of help that we offer is actually to represent you to appeal the permit that's been issued to that particular corporation. So a toxic waste incinerator coming into your community, or a factory farm corporation coming into your community, who obtains a permit, applies to the permit, the state agency issues the permit. What environmental law has consisted of for the past 40 years of environmental law being practiced is actually environmental lawyers trying to challenge the permit that's been issued. So just to be very practical here in Pennsylvania, a toxic waste incinerator, if you want to put in a toxic waste incinerator into a particular community, and I know most of you, that's probably your dream of putting a toxic waste incinerator into a community, but if you want to put an incinerator into a community, you apply to the Department of Environmental Protection for a permit, for permission to put that incinerator in. As part of the regulatory structure, as part of the regulations that have been written to govern the issuance of that permit, it used to be that you had to put a bond in place to bond the roadways that your trucks would use to go in and out of that particular facility. And that bond used to be $300,000 that you had to post with your permit application that you would put in. As an environmental lawyer, we would sit in a room and actually take the corporate permit application, compare it against the environmental regulations in place that control the issuance of that permit, and try to find gaps, omissions, and deficiencies within the permit application, so that we could argue that the issuance of the permit to the corporation was done erroneously, that it was an error of the State Department of Environmental Protection to issue the permit in the first place. So we would look at the application, and it would have a $200,000 bond that was attached to the permit instead of a $300,000 bond. Or the application had to be signed by the president of the corporation, but instead when we went through the paperwork, it was signed only by the secretary of the corporation. Or a hydro study had to be done, and the hydro study that we found with the application was 10 years old, so it wasn't in compliance with the regulations. So we would end up in front of judges, arguing to the judges, Your Honor, under section 23, little d, little I, little 2, little Roman numeral 2, little I, little d, little 2, little c, little I, little e, that the application never should have been approved because the regulatory minimum had not been satisfied, because we had found these gaps, omissions, and deficiencies. Well, most of the time the judge would agree with us. He would agree with us on our point, and he would agree to overturn the permit. Not because we were silver-tongued lawyers, but sometimes you win the battle simply by showing up. In the United States, 95% of all permits issued to corporate projects are not appealed by the communities, because the communities lack the resources to actually bring the appeal in the first place. So in some ways, just by being reasonable and doing the research and showing up in front of the judge, you've got a good shot at winning. The issue was when we would win those permit appeals, that when we would go in front of the judge to actually overturn the permit, that everybody would be really happy. Our clients would be really happy, and they would have a victory party. And so we would go back to their house, and we'd have some snacks, and we'd have some beer, and we'd pat each other on the back, and the community group would say, the system worked. They say we came together around a kitchen table, we had a problem, we decided to try to solve that problem, we found a lawyer who could at least speak intelligibly, and a judge to listen to our argument. Now he's throwing the permit out, we're not going to get the toxic waste incinerator in our community. So that was the victory party. Well, what would happen 3 or 6 months later? The corporation would come back, and they would fill in the gaps, omissions, or deficiencies that we had identified. In fact, after some of these hearings in front of the Environmental Hearing Board and other courts in Harrisburg and Pennsylvania, I would have opposing counsel from some of the largest corporations, representing some of the largest corporations in the United States, who would come over to me and thank me for finding the gaps, omissions, and deficiencies in the permit application, because they could then build the company for another round of permits, so that they could actually fill in what we had found for them in that process and actually complete the permit application. When the corporation would come back with a new and improved permit application, the community group would come back to us and they would say, Mr. Linzey, we need you to do that jujitsu again that you did the first time around to actually get the permit kicked out. And we would be left in a situation where we would have to say, we're sorry, there's nothing left that we can do for you anymore because we don't have any leverage points anymore. There's no leverage because the corporation has now submitted a complete application that meets all of the regulatory and statutory requirements. The nasty little secret of this entire process, which we call the regulatory system, it's almost like a hamster wheel that's built to frustrate, discourage, and dismantle groups in the process, is that during that process, of course, when you walk into court, when the permit has been issued and you walk in to argue over these permit appeals, if a corporation's application has been deemed complete, in other words, filled in all the holes, that you are operating under regulations that have been written by the very corporations that ostensibly are supposed to be regulated by them. So I worked in Harrisburg for a while, and I watched as the agribusiness corporations drafted their own laws and handed them off to the House and Senate Ag Committee, right? It's how sausage is made in Harrisburg, which is rarely about protecting people or the environment, but instead is about corporations directly writing the laws and then sending it through the process to be rubber stamped by those ag committees and by the legislature. So in some ways, by the time you step into the regulatory process, hell, by the time you learn about the corporate projects that's been granted the permit in your community, it is the 8th inning already, and you're down 142 to 1. And you only have the 1 if you're lucky. You know, it could run in the negatives at that point on your side. But the fact is, your both hands are tied behind your back. And chances are, even if you win the regulatory permit process, which tells you what issues you can raise and ones you can't raise, even if you win that, chances are you're winning almost nothing at all. Because all you're getting is setbacks, move from 10 feet to 40 feet. You're getting a parts per million measurement so that the project, if it comes in, may cause a little less harm, but it's still coming in. So a couple things that we learned from that period of time. It took us about 7 years to learn the hard lessons of these things. We had a win-loss record of like 190-4 in front of these administrative agencies. But if you walked into the communities that we were representing, you would see no resemblance between our win-loss record and those communities. What was funny during that period of time is that that didn't seem to matter to some constituencies. You know, environmental law is basically about making sure that the current environmental laws are enforced through that regulatory process. And so we got recognition, we got funding, we got awards, we got invited to the White House one year by Al Gore as one of the best environmental law firms in the nation. But that win-loss record, which didn't represent what was actually happening in the community, was pretty irrelevant to that award recognition structure, which was only about, you know, making sure that we were in there duking it out, but if we lost again, that was okay too, because at least we were enforcing those environmental regulations. So the two lessons that stand out to me during that period of time, two people that were much smarter than I was during that period of time actually told me these things. But first off, the corporations, when they spend money to oppose us in the permit appeal process, when we begin doing those permit appeals and forcing them to oppose and defend their permits in those regulatory agencies, the monies that they spend, I didn't know this, the monies that they spend on their lawyers to actually defend you, to actually force their project into your community, they are tax deductible to the corporation. Tax deductible as reasonable and necessary business expenses under the law. So they can deduct the cost of the lawyers that they hire to actually overturn you and drive themselves into your community. Perhaps the phrase that came to haunt me the most during this period of time, a woman named Jane Ann Morris out of Wisconsin came up with the phrase. She said, the only thing that environmental regulations regulate is environmentalists. The only thing that environmental regulations regulate are environmentalists, because they make us predictable. They make us predictable as to how we defend communities, because the corporate boys have written the script under which we do our defense. And if you're the corporation, you're writing the regulations under which communities are supposed to operate. Why would you give any power whatsoever to the community to stop the project from coming in? Why would you do that? What is your incentive to actually give any power whatsoever to the community to be able to stop the project from coming? There's no incentive. Of course, you're going to write the permit regulations and the regulatory structure to ensure that the community is divested systematically of any power whatsoever to actually stop the project from coming into the community. It's 1 + 1 = 2. But in some ways, our brains have been so scrambled to think of this regulatory process and environmental law as somehow being democratic in nature, that we abide by the decisions once they're issued. But in reality, they're about as anti-democratic as decisions get, because the rules are being written under which we fight, and someone else has scripted, in essence, the result of that regulatory fight in those regulatory agencies. It's why 45 years after the major environmental laws were adopted in the United States, that by almost every major environmental statistic in the United States today, things are worse than they were 45 years ago. Right? Worse now than they were 45 years ago. Somebody in one of the prior presentations, I think it was in Ohio, he said, well, that's not true. The rivers don't catch on fire anymore. Well, if that's our standard, then we don't want the rivers to get it. I guess we're doing okay. So for 7 years, we labored in those trenches, the regulatory trenches. We had about 100 community groups across the state of Pennsylvania that we represented as our clients. At some point, after going through that process of helping corporations build better permit applications, which in essence was what we were doing, we were assisting them to build stronger permit applications, we decided to quit that work. And we decided to shut down the office. Some of us talked to each other and said we'd rather work at Kinko's than do the stuff that we were doing, because we were actually being part of the problem rather than part of the solution. And it was about that time period, 1999, 2000, when calls started coming into our office of a different flavor. I don't know whether it was something in the water or something in the air, but things started to change. And the first thing that started to change, and by the way, we lovingly refer back to that first period of time, those first 7 years, as Groundhog Day. I don't know, anybody's ever seen the movie Groundhog Day with Bill Murray? He lives the same day over and over and over again. We felt the same way. We would wake up every day and go through the same process, for inherent reason. So when the calls about 2000 started to change coming to our office, they started to change because the communities themselves who were experiencing these corporate assaults, these corporate projects, started to challenge us. That's when it started to change. So we would get calls into our office and they would say, Mr. Linzey, we've got this factory farm or corporate water withdrawal project or incinerator coming into our community, and we want to say no to it. And again, we would put on our lawyer's hat, because we still weren't that advanced in terms of the thinking about what else was possible besides the regulatory stuff. And we would say to them, well, we're with you. We would like to say no to that thing coming in as well, but you're not allowed to, because if you attempt to do so, you're banning illegal use, and then there's legal ramifications to that. To which the person on the other end of the line would say, why? Why are we prohibited from banning illegal use? And so we were on the phone, we'd say, oh, so happy you asked that question, we know the answer to that. And we would say, if you attempt to do so, you're going to get sued. And you're going to get sued by the corporation whose constitutional rights and other things are being violated by your actions within the municipality. And so you're asking for a lawsuit at that point. You're going to get sued by the corporation's probably going to win, because it's got the law on its side at that point. To which the person on the other end of the line would say, why? Right? Why do corporations have constitutional rights? And we would say, hey, we're happy you asked, because we know that one too, right? Starting in the late 1800s, the U.S. Supreme Court and other courts in the United States started recognizing corporations as persons under the law. And as persons under the law, corporations have some of the same rights that you have in the United States. So we generally think of constitutional rights, especially Bill of Rights protections, only belonging to natural persons. In other words, bipeds walking in the United States. Because that was, of course, the original intent of the Bill of Rights, was to protect real, living, breathing, natural persons. Well, in the 1800s, late 1800s, the courts decided otherwise, and they decided that corporations have constitutional rights. So you may have First Amendment free speech rights, but so does Walmart Corporation. You may have Fifth Amendment rights against takings of property, but so does the Smithfield Foods Corporation. And because a corporation of that magnitude generally has more resources than you, they can enforce their rights more than you can, which gives rise to a situation in which corporations generally have more rights than the people that live in the communities in which the corporation is trying to use, right? So there's a power imbalance. To which the other end of the line, if they hadn't hung up already, so we had some hang up, but they would say, why, right? Why do corporations have those rights? Well, we said, the U.S. Constitution is written a certain way. You know, when most people extol the U.S. Constitution, oh, U.S. Constitution is so great, blah, blah, blah. They're actually talking about the end of the U.S. Constitution. They're talking about the Bill of Rights. They're talking about the 14th Amendment. They're talking about the 7th Amendment right to a jury trial. They're talking about all the rights-based stuff that's in the U.S. Constitution. But that rights-based stuff isn't in the U.S. Constitution at all. It's attached to the end, and we forget that those who drove the Bill of Rights into the Constitution had to do so over the objections of the Founding Fathers, right? There had to be a revolt of sorts to actually jam the Bill of Rights into the constitutional structure. Until we began this work, we didn't know how widespread that revolt was. But the states that were asked to ratify, the people in the states that ratified the Constitution, would not have ratified the Constitution without the addition of a Bill of Rights, right? They would not have ratified the document. We would not have the U.S. Constitution today if it was actually passed through Congress, ratified through Congress, without a Bill of Rights. That's how important that Bill of Rights structure was to the folks in the 1780s. So when we extol the Constitution, we're talking about that Bill of Rights piece in the last part. But if you look at the structure of the actual text of the Constitution, it's not a very democratic document, right? And we're going to talk about that later. But the essence of it is that the document itself protects certain property rights, certain commerce rights, and property protections above the rights of people, communities, and nature. That's the DNA of the text of the body of the Constitution. And if you're going to protect commerce and property that way, actually with the highest powers within the Constitution, the highest rights within the Constitution, it makes logical sense that you're going to afford corporations, who are the predominant vehicles of commerce and property, with the same types of rights and protections that you're going to afford to commerce and property within the constitutional text. That's why it was so easy for the U.S. Supreme Court and the other courts to find corporations were persons. I mean, after all, what is this, bizarro world? You know, a corporation is a piece of property. It's a piece of property that you buy and sell. It's almost as insane as if your refrigerator had rights. Your refrigerator has constitutional rights. And then to make it worse, your refrigerator sues you. Right? Because a corporation is a piece of property, but it can sue you. It can sue your municipality, it can sue your government, just like a refrigerator, if a refrigerator has rights. They're property. And under this screwed up system that we have, unfortunately, property itself, not just the owners of the property, but the property itself has been given constitutional rights. So if that's not screwy, I'm not sure what is. If you have a Friday evening where you want to do some light reading and you want to pick up the U.S. Constitution, page through it, and want to find out what's in it, refresh your memory from last month when you also read the Constitution. You might look for certain words. Certain words, like a word search, like a game. Well, you look for municipality, it's not in the Constitution. Look for the word community, not in the Constitution. Look for the word nature, not in the Constitution. Look for the word ecosystems, not in the Constitution. Hey, let's look for labor in the Constitution. It's not there, except in a provision that talks about bonded labor and returning bonded labor to the owners of that labor, right? Which is still in the U.S. Constitution. That's how it refers to labor in the U.S. Constitution. Again, if the guy on the other end of the line was still there after we had finished this exposition, they would ask one more question, which was, why? Right? Why is the U.S. Constitution written that way? Right? Where does it come from? Well, the short answer is it comes from something called English common law. Right? This body of law in England that developed at the worst time in England's development, when private state capitalism was beginning to emerge in England. Like, for example, you used to be able to get water for free from the Thames River, so a lot of poor folks used to take water from the Thames in buckets. And then this early private capitalism stuff began to privatize those services. So people had to buy water from water companies that had been chartered specially by the state as a monopoly. So it was this emergence of early state private capitalism. And in addition, it was a time period in which England was colonizing other places, like the Bahamas, or like the eastern seaboard of the United States. And England was then superimposing a certain system of law on those colonies that it was establishing across the world. We forget sometimes, I did at least, that our early states were corporations. They were private corporations. Virginia was started as a private corporation to suck the resources out of the land that was not ours, but that we called Virginia, to actually take those resources out. And so the miracle of the American Revolution was that it transformed private corporations that were owned, bought and sold and owned, into public constitutionalized states. That was the ground-shaking seismic effect of the American Revolution. But our stuff is based on English common law because that was the system of law that our founders knew. So most of the lawyers that were founders, that was the English system of law that they knew. And if you read back through the minutes from the Constitutional Convention in Philadelphia, again, if you have a Friday night, you want to read something light, it's 900 pages and it's about the type size of an ant. But you can read through the whole thing and see what the founders actually thought about you, right? Thought about you, because they distrusted the rabble. You're the rabble. These communities that want to stop factory farms and those types of things are the rabble. And they wrote a constitutional document that in effect shielded government from your control. They distrusted democracy. And they knew English common law because all the law books were about English common law. So they attempted to replicate that system of law. We're going to talk more about that in a couple minutes as well. So, person on the other end of the line, 90% chance they're not there anymore. But if they were, they said, why is that? Where did English common law come in? So we don't know. I don't know the answer to that, right? But those why questions that built up were actually the basis for our democracy schools that Chad mentioned. So we run these 2-day trainings for folks that, that really are gluttons about figuring out where this law came from. Because the tragedy of the matter is that if we don't figure out where this law came from, we can't dismantle it. We don't know what we're dismantling unless we know the shape of that which we are dismantling. And the history is kind of tragic, and it has a bunch of twists and turns to it throughout the whole process. So when we describe this to communities, a lot of the communities said, well, that's just way too difficult. We just can't grasp onto that. We don't know how to use it. And then we got a call from a little place called Wells Township in Fulton County, population 500 people. Very south, most south central part of the state up against Maryland. Population of 500 people in the township, and that township was faced with plans for 5 new corporate factory farms coming into that little township. Township supervisors called us and they said, Mr. Linzey, we don't want those factory farms coming in. We put on our lawyer's hat again and said, well, that's great, but you can't say no to them coming in. And he said something that stuck with me till today, and longer, I hope, which was, we don't care. We don't care. I said, what do you mean you don't care? You gotta care. You might get sued, you have to pay out money, you might bankrupt the township. I mean, $1 million damage award against a township of 500 people. What do you mean you don't care? You gotta care about this stuff. And he said, well, here's what we think. He said, if we have a couple options. We have 3 options, he said. The first option is to say, do nothing. And if we do nothing, then we're in a situation in which we're going to get the factory farms, right? You sit back, you watch bad TV at night, you eat Cheetos, you're going to get the factory farms coming into your township if you do nothing. He said the second option is actually to try to appeal the permits. In Pennsylvania, there are certain permits that are needed to operate corporate factory farms in general in the state. We can appeal those permits. Unfortunately, that regulatory process about those CAFO or corporate factory farm permits only allow you to argue about liquid hog manure being put on the ground and how much you're allowed to apply per acre. So you basically have a shit argument between the state and the entity. So you bring in your poop expert and they bring in their poop expert, and then the judge issues a poop decision, which is basically how it processes through the regulatory agency. Or third, the supervisor, Kevin Bricker, who was chairman of the supervisor, said, we do something new. And we actually think outside the box. And we try to do what we actually think needs to be done anyway, which is to say no to this thing coming in. And I said, well, you know, if you say no, you're going to get sued. And if you get sued, guess what? Under this system of law that we have in the United States, the lawsuit that comes in the door not only seeks to overturn the law that you've passed or the decision that you've made, it sues you for damages. The corporations are legally entitled to sue your municipality for damages. That's money damages incurred as a result of the passage of the ordinance in the form of something called future lost profits. Right? So the corporation can claim that they're losing money on the basis of your decision or your ordinance that you passed in your municipality and sue you for violating their civil rights, their constitutionally protected rights under the law, and actually sue you for money damages. And it gets worse. They can not only sue you for money damages, but they can also sue you for attorney's fees, seeking to force you to pay the cost of their lawyers who are suing you, who are suing your community, right? This is why communities don't do anything, right? They're frozen. They're paralyzed. Because who wants to get sued, right? Especially who wants to get sued on the chance that you may bankrupt the municipality, right? Those are pretty high odds, pretty high hurdles. And so we explained that to the Wells Township folks. And again, they said something that stuck with me all along, which is, we don't care. And I said, well, how is it that you don't care? What's your thought process there? Because it's eluding me at the moment. And Kevin Bricker, the chairman of the supervisors, he said, well, here's our logic. If we do it, maybe somebody else does it. And if they do it, maybe someone else does it, and then maybe tens of townships do it, and then maybe 100 townships do it. And then we have a critical mass of municipalities, a critical mass of communities who are saying, we're not going to do this anymore. We're not going to fight under a rigged system anymore. We're actually going to make structural change to reserve the right of us, ourselves, in this community to make decisions about what the future of the community looks like in the next 20, 40, or 60 years. That's what we think, he said to me. And I said to him, that's nuts. That's not how shit works, especially in South Central Pennsylvania or in the rural T in the state, which has been the dumping ground for over 100 years for all the bad stuff that comes out of the other wings into that area. And he said, well, we know you think we're crazy, but would you help us draft something that does what we want to do? And we said, sure. Well, we're along for the ride at this point. And so we drafted a local law. And the local law was an anti-corporate farming law. It banned certain corporations from engaging in farm operations within the municipality. We didn't dream them up. Farmers and environmentalists and community leaders in 9 states in the Midwest had previously adopted similar laws. They're known as anti-corporate farming laws. And in South Dakota, they took it one step forward. They took their anti-corporate farming law and they drove it into their constitution as an amendment. As an amendment called Amendment E in South Dakota. It became part of their state constitution to ban corporations from engaging in farming within those states. So what we took was, we took the state model, the template, we actually modeled it down into an ordinance, a local law, and we gave it to them, and they passed it. They became the first municipality in Pennsylvania to actually ban corporate farming against everybody telling them that they can't, right, under the structure of law. Well, what happened next was 3 other municipalities in Fulton County passed the same thing. And then they migrated north to Bradford County. And then migrated to the east, migrated to the west into Indiana County. At one point, about 12 townships, about a dozen townships had begun to pass these laws. Basically openly giving the finger to the state, who was telling them that you can't do certain things about corporate factory farms at the local level. About that time, other communities began contacting us. Issue that's become huge, not only in Pennsylvania, but other states. The land application of sewage sludge in Pennsylvania and also in other states. Sewage sludge is the stuff that comes out of centralized wastewater treatment systems, can contain thousands of different contaminants. We've had a child die in Pennsylvania after being exposed to land-applied sewage sludge. The United Mine Workers, UMWA, got active for a while around sewage sludge because their workers were getting sick working on reclaimed mine sites that were being reclaimed with sewage sludge, which is something that's allowed in Pennsylvania under the law. And so communities started calling us. They said, Mr. Linzey, we've heard what you're doing with these communities on the anti-corporate farming laws. Guess what? On the sludge issue, there's a small handful of 4 corporations that control 80% of sludge hauling in the United States. Our sewage treatment plants pay corporations to haul the sewage sludge from the treatment plants and give it for free on the back end to farmers as a replacement for chemical fertilizers on their farms. Small handful of corporations. They say, can you draft us something similar for communities that want to ban sludge, to ban sewage sludge from coming in? And we said yes. So we customized the ordinances to deal with sludge, with anti-corporate sludging laws. First, one community passed the law, then 20, then 40, then 60. We were up to 83 communities at one point. So just to set the stage, and we've been talking really quickly tonight, but just to set the stage, about 100 communities, 100 municipalities, out of about 1,000 rural townships in the state of Pennsylvania. So about 10% of those municipalities had passed these laws, which were pretty groundbreaking. They were communities not afraid to move forward to do something that they had been told that they couldn't do. As everybody in the room knows, for every action there's an equal and opposite reaction. And 2 things happened, because this is Pennsylvania, but it wouldn't necessarily have happened differently anywhere else. The first was that one of our communities got sued. A little place called Belfast Township in Fulton County. Got sued and passed one of these anti-corporate farming laws. The sheriff shows up at the door to the municipality and delivers a lawsuit that has been filed in county court to the supervisors. And the backdrop to this is that for at least 2 years while this process was ongoing, so from 2001 to 2004, right in that time period, we have been trying to talk to township supervisors and communities about this thing called corporate constitutional rights. How it doesn't matter what you pass in many ways. Doesn't matter who you elect in many ways, because your government is put into a box. And part of that box is defined by those corporate rights, those corporate constitutional rights, which give corporations power and rights against your local government. And by and large, when we were talking to the township supervisors, their eyes would glaze over. And they would say, we have no freaking idea what you're talking about these corporate rights. Maybe something you learned in law school, maybe something you learned someplace else, but don't bother us with this stuff because we live in a democracy. And if we choose as the elected government to actually adopt an ordinance that stops something that we believe is harming us, we have the right to do it because we live in a democracy, right? So don't bother us with that corporate constitutional rights stuff. We don't want to hear it because we've done what we need to do, and now we're just going to proceed to enforce the ordinance. Well, the lawsuit shows up on the doorstep of the Belfast Township Supervisor, and the lawsuit says on the front page, still have it back at the office, this is a long time ago, it said, we are agribusiness corporations, the plaintiffs, we are persons under the law, and your ordinance violates our constitutional rights. Specifically, their equal protection rights under the 14th Amendment. Because the law, while it bans corporations from farming, doesn't ban individual farmers from farming. And because corporations have equal protection under the Constitution, you have to treat corporations equally to persons in the municipality. So when you distinguish against corporate persons, but not against farm persons, that you're violating the 14th Amendment equal protection guarantee under the Constitution, right? That's the theory. That's the law, that corporations have those rights. And they use those rights to sue communities like Belfast every single day in the United States. At that point, the Belfast supervisors slapped themselves on the head and said, now we understand what Mr. Linzey was trying to talk about with the corporate rights. It's not academic. It's also not something that only affects campaign finance reform. You know, Citizens United has become a sexy issue over the past couple of years. That's the least of our problems, right? I mean, it's a problem, but it's the least of our problems. Corporations have been using constitutional rights for 120 years to run our communities, to actually govern them through this punishment system in which, like Pavlov's dog, they're able to come in and trigger our fear mechanisms about the structure of law that gives them the power to actually punish our communities for trying to build sustainability, which in essence we can't do because the corporations coming in with that law on their side have no interest in building sustainable communities in your community. Their interest is in sucking it dry. Whether it's the aquifer they're after, whether it's the land for the factory farms, whether it's the frack water injection well where they want to dump shit water into your municipality. We have a community in Indiana County today that's fighting a plan to put 227 million gallons of toxic wastewater down an injection well in their community. Right? The law is not on their side. The law is on the side of the corporation and something to put it in. Right? So in Belfast Township, what happened? Well, the supervisors used the internet of that day, which is still not very sophisticated, but faxed it all over the state of Pennsylvania. And we got a call from a little place called Porter Township in Clarion County, just above Pittsburgh. And the Porter Township supervisor said to us, well, Mr. Linzey, if we understand this correctly, we can pass any kind of ordinance we want. We can pass any kind of local law that we want. But as long as these corporate rights are in place, they can be overturned. They're not worth the paper they're written on because they can be overturned by the corporations that are affected by our ordinance. And we said, what do you want us to do about that? Right? Which is a little law firm. We're just puddling around Pennsylvania. And they said, we would like to draft a local law that strips corporations of certain constitutional rights within our municipality. Right? And we said, you can't do that. Right? Only the U.S. Supreme Court can do that. Right? They're the ones that declare whether corporations are persons or not. That's the law in the United States. And they said, we want to do it anyway, because the fact of the matter is that if we can't make law to protect our health, safety, and welfare in our municipality, then our lawmaking power, our oaths that we take as elected officials to protect the health, safety, and welfare of our community, we cannot live up to those oaths. We cannot fulfill those oaths, because we're stuck in a system of law that prevents us from fulfilling those oaths. So they asked us whether we'd be willing to draft a law for them to adopt, and we said yes. Again, we were along for the ride. And we drafted a corporate rights elimination ordinance, which actually stripped corporations of certain legal rights and constitutional protections within their municipalities. Right? We didn't know if people were disobedient enough to the system of law to actually pass something like that. So I drove up there from Chambersburg after I'd given it to them for their meeting that night, keeping in mind, probably nobody's been in Porter Township, but Porter Township is so poor that they don't have a township building that they needed. It's actually the silo building where they keep their salt, the salt for spreading on the roads in the winter. So when you walk in, they have a bunch of folding chairs around the salt mound in the middle, and they have a light bulb hanging from the ceiling. It's like a bad horror movie, swinging back and forth. And I watched that night, and people came to that township meeting. They came with copies of the Pennsylvania Constitution in their back pocket that they had downloaded from the internet. You know, Article 1, Section 1 of the Pennsylvania Constitution, all democratic power resides in the people. All power is in the people. So a guy got up and said, how is that possible when we have corporations who can dictate through their constitutional rights and corporate rights what happens within this municipality? There was some World War II veteran who came and said, I was fighting overseas for democracy, and then I came home to find out that we didn't have it here. So a conversation that hadn't happened in Porter Township probably in 200 years, maybe a little bit more than that, of people saying we need to do something structural. We've become too obedient to this system of law that divests us systematically of almost all democratic governing power over the future of our communities. And they became the first municipality in the United States to actually adopt a law stripping corporations of certain constitutional rights and powers at the municipal level. It was fun reading the newspaper the next day. They had headlines, corporations not persons, says township. I mean, good stuff coming out. Finally, the real conversation that needed to happen in these places. After Licking and Porter passed those township ordinances and became the first in the nation to do so, the work continued to expand. And so other municipalities in other places across Pennsylvania continued to pass these laws and continued to begin a conversation about corporations and corporate rights and the imbalance between those rights and the rights of people in municipalities. The second reaction, in addition to the lawsuit that came in, was your legislature took action. Your Pennsylvania, it used to be mine, your Pennsylvania legislature took action. And what they did was they passed a bill that was written by the agribusiness industry called ACRE, known also as Act 38. ACRE is Agriculture, Communities, and Rural Environment. That's what the legislature was called. And what the legislature did, after the hemming and hawing of the agribusiness corporations who were running into these local laws across Pennsylvania, was they wrote a law that authorized these agribusiness corporations to pick up the phone and call the Attorney General's office of Pennsylvania. And the Attorney General would actually assign an assistant AG to represent the agribusiness corporation within the municipalities that had passed these laws. And if the municipalities did not repeal the laws, that the Attorney General's office would sue them in the name of the state. Okay. So not the name of the private corporation, not Smithfield Foods Corporation versus Lehigh Township. Now it was Commonwealth of Pennsylvania versus Lehigh Township. And again, we've been moving pretty quickly tonight, because this is like a 10-hour seminar that we give through the democracy schools. But let's pause to savor that for a moment. Okay? You're an agribusiness corporation, you're Smithfield Foods Corporation in the state of Pennsylvania. You run into a local ordinance that interferes with your ability to put a factory farm into that particular municipality. It used to be that you would collect your funds, even though they were tax deductible, hire the lawyer, and then sue the municipalities. You'd sue the communities across the United States. You'd chase them and you'd sue them. Under this bill, all you have to do is contact the Attorney General's office, and the Attorney General will dispatch an assistant AG into your municipality to threaten your municipal officials that if they don't repeal the law, that they will sue them, not as the corporation, but as the state. The Attorney General is a public law enforcement officer. He's supported with your taxpayer funds. Your taxes are now being used to subsidize the legal expenses of the corporation, which would otherwise have to hire a private lawyer to come in to sue you, but instead your state is now providing lawyers to those agribusiness corporations to sue the municipality, right? In some ways, it's like the body eating itself, right? Because municipalities under the law are treated basically as wards of the state. They're entities of the state. But here's the state directly attacking these municipalities to eliminate their lawmaking capacity to pass these kinds of laws. There's been about 24 of those lawsuits in Pennsylvania so far, and the Attorney General has won all of them. Right? In a little place called, just to give you an example of how it works, a little place called East Brunswick Township in Schuylkill County passed a law to ban sewage sludge spreading in their municipality. The Attorney General contacted them and threatened to sue them. What happens in these municipalities generally is that the communities back down. They can't afford a resourced battle with their own state that has almost unlimited resources, because after all, they're using their own money to sue them, taxpayer money to sue them. And so the Attorney General comes in and they hammer out deals with these municipalities. They say, if you repeal the ordinance, we'll help you rewrite it. Well, in East Brunswick, they helped them rewrite it to ban sewage sludge spreading on Christmas Day and Thanksgiving. Right. So you go from a ban on sludge to then a ban on 48 hours of sludge spreading, essentially, over these specific periods of time. So that's how ACRE has operated within Pennsylvania. For us, it was actually a good thing, because most people think that corporations are the problem. They think that the problem is the corporation that they run into is proposing a particular project within their community. Well, the problem isn't the corporation at all. I mean, it's a piece of it. The problem is your own government. The problem is your own system of government. It's the Pennsylvania legislature, it's the agencies. Your government is no longer working for you. And in fact, some would say your government was never working for you. It's on the other side. And so ACRE in some ways, and these lawsuits that have been brought in the state of Pennsylvania, were a wake-up call for folks to begin learning that it's not the corporation, but actually the structure of government itself. Funny aside to that story, when East Brunswick was sued by the state of Pennsylvania to force them to repeal their ordinance, Next door, a little place called Packer Township in Carbon County passed a law suspending the authority of the Attorney General's office to adopt an anti-democratic law. So that was Packer Township and the response to that. Since Packer Township, this work has spread across Pennsylvania. As Chad mentioned, we have 100 communities across Pennsylvania who have passed some similarity or some version of these laws. And the work has spread outside of Pennsylvania. So the first place it spread was to New Hampshire, where Nestle Corporation was trying to suck aquifers dry to bottle and sell overseas bottled water from that aquifer. And so communities there picked up this work. New York, one community in New York began working on fracking issues within this community rights kind of framework. Ohio, mostly fracking issues in Ohio that people have taken on through this work. Colorado, also fracking issues, frack wastewater injection well issues in both those states as well. In Oregon, you're talking genetically modified seeds. You're also talking pesticide spraying from helicopters, large-scale water use. Now coming into vogue is opposition to these gas pipelines, which are scheduled to crisscross various states. The ordinances that we help folks draft generally have three components to them. And those three components are that we assist communities to draft laws that adopt local bills of rights, that actually recognize that communities have a right to clean air, to clean water, to a sustainable energy future. And not only as a resolution. We're used to passing resolutions and writing letters and doing all the stuff that we're told is democracy. Trying to get certain people to do certain things and begging and pleading regulatory officials and that kind of stuff, or passing statements of intent, or circulating petitions that we get people to sign that urge others to do something or the other. This is about actually seizing your municipal government. Seizing your municipal government and using it to establish enforceable, binding law that secures your rights within the municipality and then prohibits activities or corporate projects that violate those rights. After all, it would be kind of stupid if we recognized our rights but then allowed projects to come in that would violate those rights. That wouldn't make any sense. And so these local laws do both. They actually ban those activities which violate the rights. And finally, these ordinances have a third component, which is the most controversial part of the ordinances, which is the stripping of certain corporations of certain rights and powers within the municipalities, and also carving out the authority of the ordinance from state authority, from state or federal authority. So in any laws that violate the ordinance itself or the rights contained within the ordinance are deemed null and void within the municipality. The reason for that, of course, is that this represents an advanced form of activism. We know that the communities might get sued. And knowing that they're going to get sued, we know the blueprint for those lawsuits. We know the legal doctrines that are used when those lawsuits come in. The corporate lawyers have done this so many times that they have them basically as their background picture on their computer. All they have to do is pull it up and customize the fill in the blanks for your particular municipality, because the doctrines that they're operating under have been law for 150 years. And so all they have to do is put your municipality in there and then file a complaint in federal court. We know how they're going to come after you. That's what we spent the last 15 years learning, is that script that they use to actually put you in a box. The idea is to essentially build a missile that you're shooting right up their ass through these municipal ordinances to take on each of those doctrines and directly challenge them within the text of the ordinance. So when you get into court, you're no longer fighting a battle whose issue is parts per million, or plastic versus paper, or setback of 20 feet versus setback of 50 feet. Those are the arguments that we've been getting into in courts for the past 40 years. But instead, the issue becomes whose rights trump whose. Is it the corporation's rights that trump the community, or do the community's rights trump the corporation? So it's a whole different frame. The question tonight, as we've been talking at these various locations, is why now? Why does there seem to be a revolt cooking under the surface now? Why are so many people coming forward? Why is Bernie Sanders such a sensation, right? Probably wouldn't have happened 10 or 15 years ago, but he's talking a language that people are beginning to embrace. 1% stuff and the campaign finance stuff, and it doesn't go quite deep as this works, but people are beginning to hear that stuff and come to it. I think there are two big reasons why people are starting to come to this work. One is that more and more people in the United States are talking about how the United States is not a democracy, right? I don't know about you, but I've been raised since kindergarten to imprint in my brain that we live in a democracy, that the United States is a democracy, that the founding fathers are the best people that ever tread the planet. In a recent poll, most Americans believe that the U.S. is the only country with a constitution. Pretty mind-blowing, right? Princeton University, no slacker of a university, came out with a study last year, said that the United States was an oligarchy, not a democracy. Right? They looked at 1,800 policy decisions made by Congress and tried to determine whether ordinary people had any impact whatsoever on those policy decisions moving through Congress. And they found that 99.8% of those decisions had nothing to do with what ordinary people wanted. That mostly they were policy decisions preordained by the major industries that were operating in those areas affected by those policies. Even Supreme Court Justice Ginsburg, who was in Egypt last year at a press conference, and the reporters asked her, they said, if you were writing a new constitution today, which constitution would you use as a template for that new constitution? And she said, not the United States Constitution. Okay? She said there are much better constitutions out there, and that we have an 18th century system of law. Right? It's like using a computer from the 1940s. You know, we all upgrade our computers when they become obsolete. We have an 18th century system of law that might have made sense in the 18th century. You know, looking out on the landscape, the founders saw an endless bounty of natural resources. The question was, how do you write a governing document to guarantee the quickest exploitation of those natural resources to become a major world power so that we didn't have to worry about getting invaded anymore? Hello, War of 1812, right? How do we become a major world power on par with the Europeans? Well, the way that you did that was you actually developed what you had, the natural resources. And so essentially you wrote a document that accelerated that exploitation of natural resources as quickly as possible. So here's Supreme Court Justice Ginsburg, a Supreme Court Justice, saying that the United States Constitution is not a very democratic document. And if you're not going to listen to Princeton, if you're not going to listen to Supreme Court Justice Ginsburg, listen to the Pope. The Pope, of all people, on his tour, talked about economic elites in the United States making policy decisions, right? About these elites, this top tier making these policy decisions. So I think the stuff is starting to get out. The cat's out of the bag. Folks are, it's okay to talk about the fact that we don't live in a democracy anymore. Most people believe that we do, but it's okay to think in those terms that we don't. So I think that's one reason why the work is spreading. Fascinating component, I'm going to talk for another 5 minutes or so and then shut up, but a fascinating piece of this work in Pennsylvania and other places is that communities in Pennsylvania have access to something called home rule. It's one thing to pass through your municipality an ordinance. You know, in Pennsylvania, we don't have initiative power, so that citizens can't directly propose ordinances for passage outside of the cities, where some cities have and a couple scattered other municipalities. A home rule process, like we have in Pennsylvania, actually allows you within your own community to go over the heads of the municipal officials and write your own local constitution for the municipality. It's pretty exciting stuff. The first rights-based charter, the home rule charter, was adopted by the people of the township of Grant in Indiana County last November, where they banned fracked wastewater injection wells as a violation of their civil and political rights within the township of Grant. So a lot of times we get asked the question, well, if we have municipal officials that actually love factory farms, I know this area there's a bunch, or that love fracked wastewater injection wells, then people say there's nothing we can do because we can't make law. This organizing process relies on making law. It's about saying all this crap about writing letters to Congress or about, you know, buying a Prius, even though that's a big piece of a good thing. But doing voluntary stuff like replacing light bulbs is not enough to get us out of this shitstorm that we are now in terms of where the planet now sits. I don't know if folks have read the climate change stuff recently, but it appears that the climate change numbers are all off. They are off because it appears that it's accelerating twice as fast as we thought it was, which makes perfect sense. How arrogant are we that we can think that we can chart the rate of climate change and how all the variables of nature are going to play out, that we can actually put it on a piece of paper? It doesn't work that way. We broke the fucking planet, is what's happening. And in talking to college classes, you know, we open up with that. We say, we broke the planet, it's not yours, thank you very much. And so this home rule process in Pennsylvania, even if your elected officials are opposed or actually embrace these things, it's a way to go over their heads to actually write something groundbreaking. And in those home rule charters that people are writing across the United States, as well as the ordinances that they're putting in place, they contain this thing that Chad touched on, which is the rights of nature. Right now, nature under a system of law is property. You can buy and sell it. If you own an acre, a deed of land, you know, your deed to an acre of land carries with it the authority to destroy that acre of land, as long as there's no special watershed or endangered species, something like that. We have a system of environmental protection in which the more you can afford to buy, the more ecosystems you can afford to own, the more you have the legal authority to destroy. Right? That's the system of law we have in the United States. The rights of nature are about recognizing that ecosystems and natural communities have independently enforceable rights within the system of law, so that ecosystems are protected to the highest level of rights-based protection as people are within these communities who are beginning to do this work. And sometimes it's hard to bend our heads around that. What does it mean for a forest to have rights? What does it mean for a river to have rights to flow? What does all this mean, and doesn't sound like a crazy fucking thing to do? Well, the answer is it's not. The borough of Tamaqua, where Kathy is from, Kathy led the way to adopt a rights of nature law within the borough of Tamaqua. I'll remind you again, anybody that's been through the borough of Tamaqua, within the borough of Tamaqua. Right? Maybe one of the most unlikely places for it to happen, but she made it happen. Finally, again, suspend your disbelief, but the Ecuadorian Constitutional Assembly, the Ecuadorian Constitutional Assembly that was put together to write a new constitution for the country of Ecuador, all elected delegates from across the country, heard about Tamaqua. Again, heard about Tamaqua, what was happening in Tamaqua Borough. And they actually called us in to help them write their new national constitution, which was ratified in 2008 and contained the rights of nature language in the Constitution. There have now been enforcement cases. There have now been enforcement cases in Ecuador. So again, just get your brain around it. The first case was called the Vilcabamba River versus the province of Loja. People are no longer the plaintiff. The river is the plaintiff. Right? But just, you know, bends our brains sometimes to think about this, and the judge ruled in favor of the river. Right? First case in the world dealing with that particular set of rights-based stuff. So, to finish up tonight, at least for my part, the work is happening, it's exciting, it's sexy in some ways, because we can get rid of all that shit about asking a question about what can we get within the existing system, how do we navigate it the best to get what we can get within the existing system, and instead asking, what do we want, right? What do we want? Which we talk about all the time, but for some reason our activism doesn't quite get there, because it lives around these doctrines and then seeks to navigate them to try to get the best we can get within that system. So what do we want and how do we get there? Communities in the United States, as Chad mentioned, are beginning to combine themselves, because after all, it doesn't matter whether you're working on water bottling issues or factory farms or frac wastewater injection wells, it doesn't matter what the issue is, because it doesn't matter what you want within the community. It's a democracy issue, because it doesn't matter what the single issue is you're working on, you're still prevented from actually doing anything about it at the local level. And so today, communities across some of these states that have been active are creating state organizations. In Pennsylvania, we have the Pennsylvania Community Rights Network. We have community rights networks in 5 other states. Those folks are putting together state networks to drive state constitutional change that expands municipal authority to legalize what we're doing anyway, right? Because what we're doing anyway has no state sanction. This is about seizing state government to actually carve out that municipal authority at the community level to liberate people to begin moving towards sustainability. That's what that system of law is about, that change that folks are attempting to move at that level. And finally, there's an organization now called the National Community Rights Network. The state CRNs are sending delegates to the NCRN. The communities in Pennsylvania are sending delegates to the state CRN. They're sending delegates to the NCRN. And the NCRN has now drafted a federal constitutional amendment that would recognize a right of local community self-government that can't be violated by corporate rights and can't be violated by some of these other doctrines that exist in the United States that are currently used against communities. So to finish up, I wanted to read a quote. And the quote is by an author named Sam Smith. He's out of Washington, D.C., and he wrote this great book called Why Bother? Right? Why bother? I mean, the problems are so immense, the hurdles are so immense, the legal stuff is so immense. Basically what you're telling me is to stop the factory farm in our community, we have to rewrite the Constitution. Well, pretty much. Because you have to build that structure under which you can advance your values and your goals and advance law that does that. Sam makes a couple other points in his book. One, that constitutional change is necessary. We've had constitutional change in the past in this country, very rarely, but we've had it. The suffragists, the abolitionists, that women in the 1840s and African Americans in the 1850s are in the same position that our communities are in today. They're treated as property under the law, not rights bearing. You have very few rights in your community to take on a fraction-based voter rejection law or a factory farm. Women in the 1840s couldn't go into court. They weren't persons, they were property. There was no crime of raping a woman. Rape was a property damage crime. You paid damages to the husband. Slaves didn't have rights. They had rights only through their slave owners. If you killed a slave, it wasn't homicide, it wasn't a crime. You paid property damages to the husband, or to the slave owner, to the owner of the slave. Today, our communities are property. I think the best thing that was ever said in one of our democracy schools was an indigenous woman, tribal woman who attended one of our democracy schools. And she was very confused as to why white people couldn't seem to understand that they were captured within the system of law and couldn't really do anything with it. Because she said, she stood up in the class and she said, at least we know we live on reservations. At least we know we live on reservations. So Sam Smith's quote, again, then I'll shut up, a book called Why Bother? He writes, our predicament makes life simpler. We have clearly lost what we have lost. We can give up our futile efforts to preserve the illusion and turn our energies instead to the construction of a new time. It is this willingness to walk away from the seductive power of the present that first divides the mere reformer from the rebel. Above all, we must understand that in leaving the toxic ways of the present, we are healing ourselves, our places, and our planet. We rebel not as a last act of desperation, but as a first act of creation. Thank you. So as we've been doing this work, there's been some filmmakers that have approached us from time to time. One of those filmmakers was a production company called Tree Media, who does Leonardo DiCaprio's climate change films. So he's contracted with them to do a series of climate change films. They are in the end stage of producing a movie about this work, a documentary, to get more people to hear about it and begin to actually do the work. And so last week a new trailer came out and we attached it to the end of our tour visits at the last minute. But this is the trailer. It's about 2 minutes long.
Turn up on yours.
Communities across America have been poisoned by pollution, toxins, sludge, fracking, you name it.
The list goes on.
Elementary schools up here that have the wells spewing out onto the playground.
It's been a dead string for a number of years now. is a sacrifice zone.
People are trying to stop it.
We pollute our air and we pollute our water, we're actually destroying ourselves.
We get heartbreak stories every week about communities that were literally being killed by the sludge or the toxics.
But what they find is that the law is against them.
We're living in a system that does not allow representative government at the local level.
They don't want people to know what's going on here.
The current system of law makes sustainability illegal.
The problem is not toxic dumps.
We thought we had an oil and gas problem. We thought we had a fracking problem here. We realized that no, what we have here is a democracy problem.
It is the very foundations of our country.
The system that we have today we describe as a corporate state. It's in essence about a corporate minority that has been specially privileged by law itself. It's a violent, brutal system that operates.
These people are challenging the oligarchy and winning.
To bring this legislation to the table is the only option that we have.
Okay, you're coming in here with your business. Let the people know what you're going to do, and if it's so safe, then let them be the judge of that.
The movement is building.
Let the elected leaders and everybody else know that there are people who are watching.
We the people.
Do I have the right, as a citizen, as a community, to say no? And we said, yeah, we have that right.
Won't go down quietly.